Hello, my name is Hae-sun Kim, advisor of Gangnam Labor Law Firm. Today with Labor Attorney Jung Bong-soo, we will cover a special article regarding the contractor and subcontractor relationship and how those two groups should be responsible for non-payment or delay payment. And this is according to the Supreme Court ruling.
Yes.
So could you explain the story and content of the story, please?
Hello, how are you today? This is Bong-soo Jung, Korean Labor Attorney. Today, I'd like to introduce very interesting Supreme Court ruling regarding construction daily work. So, this like one construction company completed the building project, then they outsourced the AS, that means after service the project, like usually construction is completed. There are some those residents of that area complain about some some part of the, like something they can improve, or some regarding about some construction part innovation, something. Yeah. Then this outsourcing company received this outsourcing. Then this outsourcing company subcontractor hired some construction daily workers, and they have them work and repair certain part. Then this subcontractor could not pay wage, so they delayed the payment wage for several months. So this the construction daily worker submitted the petition to the labor office, and labor office the punished this subcontract, but this labor, the construction daily worker could not receive the wage, so they submit the petition again against the main contractor, like a construction company. So then main construction company told the labor inspector they already paid all some contract fee to subcontractors, so they are free from payment of this salary. But labor inspector asked them they have to pay, because they're using the special article 44 of the Labor Standards Act. So when the subcontractor could not pay their salary, then those upper level contracts should be responsible for this wage payment as a joint responsible the employer. So then, but this main contractor rejected to pay. So finally, Supreme Court ruled that this unpaid wage for construction daily worker, so their contractor and subcontractor, they are responsible for joint payment, joint responsibility as an employer. So that is this ruling. So because construction daily worker, they have a very very bad working environment, because their job is dangerous. Also, it's not permanent job, so easily so contract. So working relation is like they have their own employer and main contractor, subcontractor, and also so because the contract, usually construction worker is assigned their project to each special the contractors. So it is very combined. It's a very complicated the organization they have, because construction require a lot of the specialty in different area, like the interior or electricity, or some building the basic the basement, or some. So by showing this picture, I show you how construction industry is organized. So as we know, so this picture showed how construction the industry is organized. So client usually they want to build their own apartment, then they contact the construction company, then the construction have some building project from this client, and in order to start the building, they have a subcontract with the professional the companies, like we call specialty contractor. So there are a lot of special contractors. Then this special contractor also they outsource their work to foreman. Foreman actually they bring their the co-workers together with them, and so like a special contract they pay the some the project fee to foreman, then foreman so pay some material fee, and also divide the manpower like labor cost to each skilled workers. Yeah. So it is how the construction the project is composed, like main construction company they outsource the subcontractors, and also they hired they used a lot of foremen, and foremen bring their workers. So usually this one like usually some subcontract they cannot pay sometimes because of their internal issue or some bankruptcy something. Then skilled workers can claim unpaid wage direct to foreman, and foreman cannot pay, then the specialty contractor also they cannot pay their wages, then they can ask main construction company for unpaid wage. So this is a way how they get back the wage that they worked for. Yeah. So
I see.
this is some main building industry composition. Yeah.
So this structure in the construction site is very complicated, and so this is why one of the reasons why the Supreme Court ruling has to make the final decision, especially giving responsibility for the both contractor and subcontractor to be responsible for the unpaid wages.
Yes, that's right. Yes. So usually in construction site, so like construction usually in construction business they use almost 50% of workers from daily workers, not permanent workers. So those daily workers when they could not receive their salary, then they can claim to upper level the contractors. So then the Article 44 of the Labor Standards Act explained that very exceptional rules. There are many. The business has been implemented through subcontract workers. Then when there is unpaid wage, then contract employer and also subcontract employer should be responsible for unpaid wage together. So that's his rule. Also, court ruling is about how the Supreme Court charge the responsibility to the main contractor for unpaid wage for subcontractors workers. Yeah.
And as a representative of labor law for both employer and employee, I understand that you have written an article, especially focusing on the construction site because it's very complicated structure to represent those like unpaid wage workers. Is that right?
Yes. So that's right. Yeah. So this is like to protect the construction daily workers starting the January 2008. The like foreman cannot be the employer, so the rule was changed. So in the construction side, even though there are many subcontractors, then the specialty the construction company can be an employer. So those women who hired their workers, they'll be some workers working for the specialty construction company. So even though they hire the workers and they pay wage to the following some daily workers, but foreman cannot be an employer. Also, that is is follow the division of labor, like construction, the workers' law. It was revised in 2008. Also, the other law was changed. Then that is Article 44 of the Labor Standard Act. So that in the relation between the contractor and subcontractor, when the subcontractor's worker could not receive wage, then the main contractor and subcontractor, they are jointly responsible for unpaid wages. So
I see. So this video will give some advice to those in the construction work site, and if they are not comfortable or there's unpaid wages, they can consult with a specialist like Gangnam Labor Law Firm.
yeah. So yeah, I think about only 10 years ago, more than 10 years ago, I helped like construction workers who could not receive wages. So then even the subcontract who hired those company, so they could not pay because of their financial situation. Then I asked them, you have to submit the petition against the main construction company. Then the labor inspector will support you. So at the time, I represented them, and they successfully received their unpaid salary from main construction company. So that was the example following the Article 44 of the Labor Standard Act, like a joint responsibility for unpaid wages. Yeah.
I see. Thank you very much for your comment.
Okay, thank you for watching. Okay, bye-bye.